The FCRA Amendment Bill 2026 is all set to be introduced in the Parliament on Monday itself. And a lot of brouhaha is already expected on the issue within the Parliament as well as without. There are forces and even foreign governments and deep states of other countries that want the bill to be either defeated or postponed. However, the government must be resolute in its effort to get this bill passed in the greater interest of the country. Essentially, this bill proposes to hand the government the power to take over the assets of NGOs if they fail to abide by the FCRA registration rules. The bill had really become necessary for the entire country. It is a well known fact that in many cases, foreign remittances have been used for nefarious purposes. For example, for financing terrorist networks and running conversion rackets on a large scale. The sovereignty of the country is not negotiable, and money does have a perverse influence on the polity and social fabric of any country. No state lets foreign actors fund domestic institutions without oversight. Not the US, because it has FARA, not the UK, not Australia, because all of these countries also have equivalent acts. India delayed catching up to that standard for decades out of a misplaced deference to civil society as an untouchable category. An NGO funded from abroad shapes local policy, media narratives, religious conversion, or protest movements is a vector for foreign leverage, whether or not any single instance is malicious. You don't wait for proof of the worst case before regulating the channel. That is what every serious state does with foreign funded political activity. If foreign money built a hospital or school on Indian soil, that asset exists because India permitted the contribution in the first place under the state's own regulatory grace. When an organization loses that regulatory standing through cancellation, non renewal, or surrender, often for real compliance issues, there is no principled reason those assets should remain outside the state's reach. They were never purely private property in the first place. They were built inside a foreign contribution regime. The state is entitled to unwind cleanly when the operating license ends. Vesting control in a designated authority so a hospital keeps running rather than getting stripped, sold off, or quietly diverted by trustees is the responsible way to handle that transition. The alternative, letting an organization that has lost its legal right to hold foreign assets simply keep them indefinitely, is the actual scandal, not the fix. Actually, the opposition to the bill is not evidence of a problem with the bill. International NGOs, foreign church networks, and UN rapporteurs objecting to India tightening control over foreign funding is exactly what you would predict if the bill is working as intended. Sovereign states are not obligated to defer to the preferences of external actors, churches, NGOs, foreign funded rapporteurs, about how they regulate money entering their own political and civic space. Parliament must pass this bill without any amendment. The bill, in its present form, addresses some serious loopholes in the existing FCRA. The burden of proof runs the other way from how critics frame it. An organization that wants to keep operating on foreign money inside India should have to justify that continued access, not the reverse. The government is within its rights to curtail the unbridled freedom that some of the NGOs have been enjoying over the years. The government must get its act together and see to it that this FCRA Amendment Bill 2026 is passed without any hitch.